The Senate Judiciary and House Corrections and Juvenile Justice Conference Committee will be called to order. Thank you, everyone, for your attendance and for following along online. And what we usually do first in a conference committee is we ask the revisor to brief the committee on bills that we have before us and are subject to conference committee. So if you will please go ahead and do that, that'd be great. Thank you.
Sure. Thank you, Madam Chair. All the bills that are in conference committee between the two committees are Senate bills. So I'm going to talk through the changes that were made over on the House side. So we'll start with Senate Bill 318. When it came to us, it was a bill removing the requirement to fingerprint people convicted in municipal court for driving without a license or driving without insurance coverage. It also included a Senate floor amendment that required the city attorney to inspect and review audio and video recordings that are relevant to a case provided by the accused person. The House removed the contents of both of those sections and replaced it with the contents of House Bill 2385, which was a bill changing the rebuttable presumption to an intent to distribute controlled substances. It's changing that to an inference. And then the second section provides the instructions for presumptions and inferences against defendants in criminal cases, provides what those instructions need to include. So you'll see the vote counts there. Moving on to Senate Bill 414. When the Senate sent that.
If we can pause for just a moment, if anyone has any questions about House substitute for Senate Bill 318. If you could go back to what it originally started as, was it a municipal court fingerprinting bill?
Yes. So when the bill was originally introduced, it in current law, people who are convicted in municipal court of driving without a driver's license or driving without proof of insurance are required to be fingerprinted once they get convicted. That's how that bill was introduced. In the Senate floor debate, there was a floor amendment added that required city attorneys to inspect and review audio and video recordings that were provided by the accused person in a case. And so that was adopted. So that's how it came over to the House.
Thank you. Are there other questions? Not seeing any, then go ahead. Thank you.
So Senate Bill 414, the way that came to the House from the Senate, it was a bill that increased the criminal penalties for distribution of fentanyl by weight and dosage unit. And it also created a rebuttable presumption of intent to distribute for possession of 50 or more dosage units of fentanyl. It also created a special sentencing rule of presumed imprisonment and 2 times the maximum duration for distribution of fentanyl when that crime was either a drug severity level 1, 2, or 3 felony. The House retained those provisions but added some other provisions. So they added a provision from House Bill 2676 that created the crime of encouraging suicide and provides criminal penalties. Therefore, I would note that provision was actually added into a conference committee between Senate Judiciary and House Judiciary. So that provision has already passed the legislature. They also added the provisions of Senate Bill 419, which increased the criminal penalties for endangering a child when fentanyl-related paraphernalia or toxic materials are present and when bodily harm is inflicted on the child. In addition, they added the provisions from Senate Bill 420, which removes concealment and secrecy from the crime of breach of privacy. And then finally, they added the provisions of House Bill 2654, which excludes certain types of incarceration time from being included in the allowance for time spent incarcerated when their criminal sentence is being calculated. And I can take any questions on that one.
Thank you, Natalie. And I'll actually note that the crime of encouraging suicide is now in law. I think the governor signed that when it was presented to her last week or so, I think. So, but thank you. Yes, sir. Go ahead, Representative Carmichael.
You're looking out for me today, Steve. I appreciate your help. Thank you, Madam Chair. I'm just a little bit asleep this morning. I'm on 414, the House version. The last paragraph says Section 6, KSA 216805, same as Section 2 from Senate version. And is is that the special sentencing rule for presumed imprisonment, or is that something different?
Yes.
Thank you.
Thank you. Any other questions? Okay, go ahead. Thank you.
So the third bill you have before you is Senate Bill 419. You'll recall that we just noted that the original provisions of Senate Bill 419 were included in Senate Bill 414 by the House in a bundle. So the House removed those provisions and inserted the provisions of House Bill 2522, which require the Secretary of Corrections to assist inmates with obtaining identification and employment related documentation. And I can take any questions on that.
Are there any questions about that? All right, not seeing any. Go ahead. Thanks.
And then the same situation for Senate Bill 420. The House put the underlying provisions of that bill into Senate Bill 414. So the current provisions in Senate Bill 420 are provisions from House Bill 2490, which limit the juvenile overall case length limit extensions to not more than 90 days each. And the provisions of House Bill 2698, which allow juvenile offenders to leave the correctional facility for certain programming and education purposes. I can take any questions on that one.
Thank you. Any questions? Not seeing any.
And that's the last bill you guys have.
Thank you, Natalie. Appreciate it. Committee, let's go ahead and pull up for discussion Senate Bill 414. That's what I would probably call the House has bundled a lot of the fighting fentanyl bills into it, and it contains a couple of Senate bills that passed unanimously on the Senate floor regarding increasing the criminal penalties for endangering a child when fentanyl paraphernalia is present, as well as, well, I guess that's the only fentanyl related one in that bill. And then removing the concealment and secrecy element from the crime of breach of privacy when you're using kind of a recording device, if I'm restating that correctly, Natalie. And we then have the House proposal there, and if we could just take a moment as a brief pause for us to consider that. Sure, go ahead with the House proposal.
Excellent. So thank you, Madam Chair. As we mentioned, we do need to remove 2676, the suicide piece, because that's already passed. So I would suggest that we remove that. But then also, I would like for the Senate to consider adding the contents of House Bill 2601. This passed unanimously out of the House. This was a fix that we heard when we adjusted DUI laws a couple of, I think it was a year or two ago. And what this does is it reinstates the ability for certain persons on a third or subsequent conviction of DUI to participate in substance use disorder treatment. That was, from what our perspective was, erroneously removed. So we'd like to add the contents of House Bill 2601 and the contents of House Bill 2741. 2741 was a product of the Criminal Justice Reform Commission that met over the course of 3 years. And what that does is it standardizes and updates the terms of supervision for offenders on probation and post-release supervision. So just some standardized terms so that community corrections, court services, parole are kind of operating on the same basic premises. So if you guys would consider that proposal, I would appreciate that.
Thank you to the House for the proposal, and I will note that both 2601 and 2741 did pass out of Senate Judiciary Committee favorably and are below the line on the Senate side. So let us take a moment and we will consider that. Thanks. standing at ease. The Senate has considered the House offer, and we'd like to discuss kind of the other three bills that are in conference committee before we make either a counteroffer or before we accept that offer. So I would propose then that we bring up Senate Bill uh, 419, please. And if we need a reminder from the revisor, does anyone need that? I don't think so. We have the chart here. And if there was a proposal from the House on that, Senate Bill 419.
Yeah, I appreciate that. Thank you, Madam Chair. You know, one of the bills that we didn't have a home for that's incredibly important to the House, and I believe the Senate has heard it, may not have come above the line, was House Bill 2487. And this provided immunity from prosecution for certain drug crimes when persons seek or provide medical assistance related to the use of a controlled substance. And so what I would propose to do, Madam Chair, is to remove the current contents of Senate Bill 419 and replace it with House Bill 2487.
Thank you. And if we could, before we consider that, if we could go through the other two bills too, that would be helpful.
Certainly.
Okay. And then let's pull up Senate Bill 414. Should have gone in numerical order because just a moment. I'm sorry. Let's go to 420, please. Senate Bill 420.
Certainly. I mean, we're satisfied with 420. I'm not sure where the Senate stands on 420. Certainly open to discussion on that.
Okay, I think with Senate Bill 420, again, we'll have to discuss that in the context of the others. And let's look then at Senate Bill 318.
Certainly, and from the House's perspective, that one really doesn't need any changes. Senate Bill 318 has the 2385 in it, which is the rebuttable presumption to inference as it relates to distribution charges. This was a result of, if I remember correctly, Judicial Council study, but also a Kansas Supreme Court ruling, because under current law, it was ruled in the Supreme Court that there was some onus put on the defendant. The burden of proof was put on the defendant, and so this attempts to fix that and was recommended. So that passed unanimously out of the House as well, and we inserted that in Senate Bill 318.
Thank you. And a question for the revisor. Without House Bill 2385, if it's a jury trial and the court doesn't give the jury instruction about rebuttable presumption, does that help resolve the issue that 2385 would be seeking to address? I assume that might be happening currently, because currently there have been trials since the Supreme Court has made its ruling that has brought up this issue. So I'm thinking that there is a workaround if it's something that needs to be further considered. Yeah.
Madam Chair, it's our understanding from the testimony that we received that the current pick instruction that's being used, follows the statute as they do. And so right now they're having to use a modified pick instruction to be in compliance with that Supreme Court decision. And I believe that's what they're doing right now, but we'd have to check with some practitioners who kind of practice in that area to be sure.
Thank you. And for those following along, PIC is the pattern instructions in Kansas, so that we use in our jury trials. except if they're modified. So the court and can modify them as well with attorneys in the case. But yes, go ahead, Representative Carmichael.
Thank you, Madam Chair. When I first heard about this bill, I didn't think it was necessary. I also have problems with presumptions that may arise by virtue of particular quantities of a substance. And the prosecutors, I think, explained to us first that they wouldn't try to go forward on a case just based upon the presumption anyway, because they present corroborating evidence. But as my chair explains, the current statute contains language which is probably constitutionally unacceptable because it says there is a presumption before the defendant ever walks into the courtroom, and then that requires the defendant to rebut the presumption, and that shifts the burden of proof. So that concept in the law has changed from when I went to law school. The difficulty is that, number one, the PIC instruction is based upon the statute, which is probably constitutionally infirm. Judges don't have to instruct according to PIC. They can modify or not instruct at all, as the chair points out. The difficulty becomes, one, it's generally a bad idea for judges not to follow PIC because that's how they get themselves reversed. And so as a general principle, judges are going to try to follow the PIC instruction. And meanwhile, the PIC instruction is married to the statute. If the judge was not to instruct at all on the point, my guess is the prosecutor would not like that, because then the prosecutor would not have the benefit of either a presumption or an inference in the eyes of the jury. And so I think the chair is right. A judge could just not instruct on the issue at all. But I don't think that's what the prosecutors would want, because even though they don't get the presumption, they at least want the jury to understand that from a certain quantity of a drug, you can infer certain other facts. You don't have to, but you can make that inference. And so I think that's the reason that the Solicitor General, the Attorney General, law enforcement, everybody I think that we heard, except for maybe a snowflake liberal like me, thought that this was a good idea. And so, I'm going to sleep well if we don't do anything with this statute. But my guess is that the better thing for us to do is to clean it up in the fashion described in the bill. Thank you for hearing me.
Thank you. Committee, any other comments or questions before the Senate recesses, or we're going to stand at ease so the Senate can discuss?
If I might go back to 420 for a second, I don't feel like I did justice in explaining the House's position on 420 and why those were important. So if you'll indulge me for just a second. 420 has the contents of 2490. If you'll recall, last year we passed House Bill 2201, which is the kind of juvenile justice reforms, or 2021, was it? Yeah, sounds right. In that, we allowed case length extensions if the juveniles were not completing their programming. What we heard during the Corrections and Juvenile Justice Oversight Committee during the interim was that we needed to define how long that extension could be, because we just left it kind of open and arbitrary. So that bill simply put up to 90 days in statute. The extensions are already allowed per current law, but we just added this clarification that it can be up to 90 days. So just wanted to clarify that. And then on 2698, I know there's been some conversation around concerns with juveniles leaving the juvenile detention facility. As you're aware, Madam Chair, there's only one juvenile detention facility. It's here in Topeka. Currently, there's no mechanism like there is in the adult population. The adult population, we have work release that begins that cycle of reintegration back into general society, amongst other ways. And so the adult population already has that. Well, these juveniles that may be locked up for a short period of time or a longer period of time are going to leave that facility, every one of them. I believe the rule is either 21 and a half or 22, is as long as they can stay there until that age. The vast majority are going to get out. There's a limited few that will just cycle right into the adult facility. This provides the mechanism for the Department of Corrections to allow those juveniles out under certain circumstances to begin to just reintegrate into society, get used to being around other people, kind of take some of those strings off a little bit to see how they do before their permanent release is allowed. So I just wanted to add a little bit of context of why we felt that those were important. Thank you.
Thank you. Appreciate that. 2698, we did have robust discussion in committee about it. And the concern was, well, this is a new program in Kansas, and that the committee was thinking, well, we need some guardrails around it and some guidelines, and what would this look like? And we do have that kind of guardrails and guidelines for the adult population, and maybe something like that for the juveniles would be helpful as well. And 2490, we did get that out of committee with some amendments, and it's below the line and was not pulled above the line. So with that, then I think that's the 4 bills in committee. And if we can discuss and come back with either we accept the House position or we have a counter position to offer.
Sounds good. And last thing I would add is I did take the liberty of attempting to draft up some language to add some guardrails to 2698. If you'll just would possibly consider that, in amongst many other things when you come back. Just keep that door open.
If you have that to pass out now,
Oh.
we'll go ahead and take a look at
Okay,
that. And
that would be
I'm
great.
thinking you had the conversations with Department of Corrections and they brought these forward.
Correct. Yeah, because we understood your concerns, reviewed your committee, and knew that there were some issues that they had. And so I don't know, we can either, you can take the time to read these, or we could kind of have Natalie speak through what she assisted me in preparing.
Well, I think for those following along online, it's probably easier if the revisor explains.
Very good.
Thank you, Madam Chair. So you'll see essentially what this balloon does is remove the underlying language from House Bill 2698, and it replaces it with the provisions requiring the juvenile to meet the appropriate classification as defined by policies and procedures that are adopted by the department in order to get that leave or furlough to leave the facility. It authorizes the Secretary of Corrections to establish a work release program, an educational release program, or a release program for other risk reduction purposes for juveniles. And if the Secretary finds that a juvenile meets the criteria for those release programs and is capable of receiving benefit from educational or vocational programs that are not available within the facility, then the juvenile would be allowed to attend those release programs outside the facility. The bill would also require the Secretary to develop policies and procedures to ensure adequate oversight, supervision, and accountability of the juvenile, including communication with community providers related to that juvenile. And I can take any questions you have.
Thank you, Natalie. Any questions? All right, not seeing any. We're going to stand at ease for just a moment so we can consider the 4 bills. Thank you. And the Senate is ready to discuss. We're going to start with 414. And the House proposal was to add in House Bill 2601 regarding to requirements after your third conviction for DUI, and then add also House Bill 2741 regarding um, uh, probation and post-conviction release. And we will have a total sum offer. So this is the part that's related to 414 that the Senate is willing to accept those as part of the package of our offer here, because so that's for 414. $26.76, yes, needs to be removed because it has already been enacted into law. So there's no reason to have it be retained in the bill. The other one is Senate Bill 419. And regarding 419 and the House offer was to remove the contents of House Bill 2522 from Senate Bill 419 and insert the contents of House Bill 2487 regarding to providing immunity from prosecution for certain drug crimes when persons are seeking medical assistance. Clearly, 2487 would be kind of an important public safety piece that for someone who's involved with maybe addicted to drugs, and you can't help them if they don't remain alive. So it's an opportunity to hopefully save some lives there. And so the Senate would accept, again, this is part of the whole package, the position of the House on Senate Bill 419 on removing 2522 and inserting 2487. I think we had brought that up, 2487, for debate, and for some reason it just got passed over. So I think we ran out of time on that one. And then that brings us to 420. 420. So 2490 was amended in Senate Judiciary and passed out favorably, but remained below the line. So for reasons, Senate leadership didn't pull it above the line. And with 2698 and juveniles leaving the correctional facility, appreciate the House work on proposing some guardrails and some guidelines. And the Senate feels that it's a little bit vague when we talk about other risk reduction purposes for juveniles. That right now in Kansas, we have no opportunity for juveniles to leave the correctional facility for any purpose and then return. So we're putting something new into law and want to make sure, again, as we see how it works and make sure we've got proper guardrails, and as we hopefully can successfully reintegrate the juveniles into societies and reduce the rates of recidivism. So with that, then it would be acceptable to the Senate, the balloon, except for the other risk reduction purposes for juveniles. We don't know, we've got possibly some, we have to make sure that the juvenile meets the appropriate classification. And does that mean they're non-violent offenders, or are we ensured that we're not releasing juveniles who don't retain adult supervision from the facility with them? They might, but that they're properly supervised and that they are the appropriate classification. So is the House position that the guardrails proposed with the change from the Senate, that that's sufficient to make sure that if you're are violent juvenile offenders going to be eligible for this, I guess is the question.
I would certainly like to confer with my colleagues as to whether removing that language is acceptable. But I can tell you that from my perspective, I feel very confident, again, because we know that unless a juvenile is being transferred from the juvenile facility to the adult facility, they're going to be released anyway, whether they have a violent history or they don't. So we know they're going to
I
get
mean,
out.
released upon having served their term.
Serving their term, yes,
Sentence.
at that, or aged out. Yeah, that would probably be the appropriate. They will have aged out and by so doing serve their sentence and be released. So we're confident the appropriate guardrails do exist because if they are going to be transferred into an adult facility, they wouldn't have the opportunity to be part of this anyway. This is only for juveniles that are going to be released back into the population or age out.
And that would include our more violent offenders as well?
If they were adjudicated as juveniles, even if they were violent offenders,
Gonna then
they're
be
still
released.
going to be released anyway.
Society, yes. Okay, so that's that. And then on, and I understand you need to confer, but you'll need to confer on all of this. On Senate Bill 318, it's clearly important that we, particularly in the area of criminal law, are following the Constitution. And we would not want to impermissibly shift the burden of proof onto defendant. So the Senate understands the issue there and would be willing to take a look at keeping Senate Bill 318 as proposed by the House with adding in the contents that were removed by the House in Senate Bill 318 as it came to the House. And that would be removing the requirement to fingerprint people convicted in municipal court for driving without a license or driving without insurance coverage, and requiring city attorneys to inspect and review audio and video recordings that are relevant to a case provided by the accused. So that's a lot to consider. So if you don't have any questions, if you want to confer or.
Sure, if you'll give us a minute to step out, we'll confer on that.
Thank you. On Senate Bill 420, the proposal from the House was well, I guess it would be our proposal on the case length extensions on House Bill 2021, that it's a brand new program. It's about a year old now. And again, that was below the line, but not pulled up by leadership. And so the Senate would not be willing to accept including House Bill 2490 in Senate Bill 420. It's something that could continue to be looked at and see next session, another year down the road with how the program in 2021, House Bill 2021 is working, and something to consider and look at further. Well, we're not adjourning, but we'll stand at ease, sir.
Before we recess, could I inquire of the revisers about the current state of the law as it relates to case length extensions in juvenile proceedings, the subject matter 2490, so as to remind me as to what change the House was making?
Sure. Thank you, Madam Chair and Representative Carmichael. I'm going to pull up the exact language here, but Last year in House Bill 2021, you guys allowed for extensions of the overall case length limit. Before that time, the probation length limit could be extended, but the overall case length limit could not be extended. And so you guys allowed.
Could I stop you for just a minute? Meaning not extended, meaning the program has to be completed within a certain number of days or what? I think it's just no more program.
Yeah, jurisdiction is released. So in juvenile cases, we in Senate Bill 367, you guys instituted something called an overall case length limit. So depending on the severity level of the crime that was committed, for example, if you are adjudicated for a misdemeanor, you can only remain under court jurisdiction up to 12 months. That's the overall case length limit. If you are put on probation and you are attending programming, but that programming is not done, you're not completed at 12 months, it doesn't matter. The court has to let go of jurisdiction of the case.
That means the juvenile is released from the authority. They go back to society not having completed the program.
Yes.
Okay.
And so in House Bill 2021, you guys allowed for extensions of the overall case length limit. And the current state of the law says that extensions of the probation and the overall case length limit shall only be granted incrementally. So the idea is, you grant it and then they can come back before the court for another extension if needed. What this bill would do, as it left the House the way you guys had it, is provide that extensions of the overall case length limit shall be granted incrementally and they can't exceed 90 days per extension because there was no cap put on that in House Bill 2021.
So under the present status of the law, if we reach 12 months, the maximum case limit, the judge can still yet grant extensions, which really means keep the juvenile under the jurisdiction of the court. And right now, is there any limitation on how long these extensions are? Could the judge incrementally increase it by 5 years or 5 weeks?
Yeah, the only kind of guardrail in the current statute is that they be done incrementally.
But without specifying whether it's 5 years or 5 weeks. But the House bill would say that you can grant extensions still yet to keep this person under the control of the court, but it's limited to how many days?
90 days
90
per
days
extension.
Per extension.
And the Senate made some changes in the Senate committee, but as the chairwoman stated, the bill was not brought above the line on general.
Can you help me? And I'm sorry to belabor this, but can you help me understand what the Senate's change was?
I'll let Jason, I have it here if you want me to.
I'd love to hear from Mr. Thompson. It's been too long.
Could we just help clarify for those following along online? It couldn't, if you're 17 or 18 or 19 and under the jurisdiction of the court, you wouldn't be able to extend it 5 years because that takes you out of the juvenile.
You were 12.
And in 2021, as I recall, was to get the kids who are just biding their time. Well, it's 12 months and, I'm not going to work it. There's nothing they can do. That was the purpose of 2021, to have them work their program because they are already in society. This does not affect those who are being held in the correctional facility. This is their, so it's not regarding detention, right? It's regarding your case program.
So it could be either of those things. So it's offenders who are in the most serious category. If you committed an offense that's a severity level 1 through 4 person felony, you don't have an overall case length limit. So those are more than likely going to be the juveniles who are in the juvenile correctional facility. But if you do have a juvenile in the juvenile correctional facility and their overall case length limit runs, then they are released. The jurisdiction is over and they would be released. But the overall case length limits range from 12 months to 18 months. depending on the risk level of the juvenile.
Thank you. And then I'm sorry, I think Mr. Thompson, you were going to say the Senate amendments in committee.
Thank you, Madam Chair. Briefly, I'll try. There were several. One broad one was providing for an evaluation of a juvenile's academic record, also providing for dyslexia screening and reading level assessments, not related to the case length limits, but those were amendments adopted in committee. And then the key change to the case length limit was allowing 2 extensions of 60 days per extension. So it would have limited both the time of the extension and the number of extensions. Hopefully that's sufficient start.
I inquire.
Just a moment. And I think, Mr. Thompson, one of the amendments required a particular facility in the state of Kansas to do the particular assessment.
Yes, Madam Chair, I didn't get into details on it, but the assessment for evaluation of the academic record was by the Jobs for America's Graduates Kansas Administrator, so JAGK, as you guys know it. And then the other was the dyslexia screening would be from someone at the Center for Reading at Pittsburgh State University or the Phillips Fundamental Learning Center. I think those are the 2. So yes, there were specific persons identified that would do these evaluations or assist with these evaluations.
Might I inquire of the revisor?
Sure.
Thank you. So, Mr. Thompson, under the Senate amendment, or at least the Senate Judiciary's amendments, it sounds to me like once the juvenile had completed the original program, not completed, once the time had run, but they had not really completed the program, they just sat at home or in jail, juvenile jail, and watched the calendar. Under the Senate Judiciary's proposal, the judge could keep them in the program and not release jurisdiction for 60 days and then an additional 60 days. But at the end of the original program plus the 120 days, whether they've complied with the program, completed the program, or whether they've just been terrible, they're released from the court's jurisdiction. Is that the way the Senate amendment would work?
Madam Chair and Representative, I think so, yes. It would have been a 2 extension limit. That would have been the end.
Madam Chair, the reason that I favor the House's proposal is it lets the judge maintain jurisdiction over a recalcitrant juvenile for as long as it takes to fix it or until they age out of the program. And I don't think any of us want to set up an artificial 120 days and now you're scot-free whether you cooperate or not.
There was concern in the Senate Judiciary Committee with the length of and the restrictions, only 2 extensions and only 60 days. So it was robust discussion. So it's not lost that that would be some restrictions there. Thank you. We'll stand at ease. All right, we will come to order again. Thank you.
Yeah,
ahead.
let's go back to it. So, counter proposal for you, if you will. So we're okay with accepting all of our stuff. The removal of 2490, the amendment, excuse
Which one are you talking about?
2490 is in Senate Bill 420, removes the case length limit,
Okay,
the
so
90 days.
what's
So
your
we're
counter?
okay with that.
Removing 2490?
Yep. And this
Okay.
is again in the global scope of everything.
Got it.
We're acceptable to the amendment in 420, which had to do with the juveniles leaving the correctional facility on the balloon. We're striking that one sentence.
Okay.
So we're good with that portion. Yeah, that portion of it. And then as it relates to Senate Bill 318, you had requested that we add back the original contents of Senate Bill 318. There is some concern on kind of where that needs to go because of the single subject rule. So I would propose that Senate Bill 318 be left the way that it currently is with the rebuttable presumption, because I think that needs to stand alone due to court challenges. But we add a portion of the contents of 318 to Senate Bill 414, which is our criminal bundle. And the portion that we are okay with is the removing the requirements for fingerprinting. Our committee heard the bill in its entirety, and the floor amendment that was brought on by the senator, which wasn't heard in your committee, on the inspection and review of audio video, we do not support that on our side. So we would be okay with adding the fingerprinting portion of 318 to 414, as long as we're not adding that floor amendment as part of it.
Thank you. Are there any questions from the Senate for the House position? If not, then let us just confer for a moment. Thank you. Thank you for standing at ease while we conferred. And I understand the single subject issue on Senate Bill 318. If we were to put back the municipal court part back into that would not work. So putting it into Senate Bill 414 is the proper home for it. So thank you for that. And the House isn't willing to accept the other part of Senate Bill 318 as it came out of the Senate. And the rest, then I'm saying that the Senate will accept the House position as it was just stated. I don't just mean the rest, but on the four bills. So do we have our revisers understanding? Yes, if you could recap, please, Mr. Thompson.
All right, thank you, Madam Chair. So we'll just go in order. That's the easiest way. 318, the tentative agreement would be that the Senate would concur with the House amendments. So just keep it as it came out of the House. 414, the tentative agreement would be to remove new section 1. That's the encouraging suicide language. Add House Bill 2601 about DUI. Add House Bill 2741 about conditions of supervision. And add Senate Bill 318, section 2 from the old version, just the fingerprint, not the other. Senate Bill 419, tentative agreement would be to remove all of the current contents and add House Bill 2487 instead, regarding immunity for assisting controlled substance use situations. And then finally, Senate Bill 420, tentative agreement would be to remove the contents of 2490 and amend the contents of 2698 to what is reflected in the balloon amendment with the additional change of removing the other risk reduction purposes clause of one of the sentences.
Yeah, I think the Senate believes, sounds like the House does too, on the other risk reduction purposes. Let's have some more study on that before we put that into this new program. So
Sounds good.
with that, then yes, go ahead, Representative Carmichael.
Thank you, Madam Chair. I don't have any problem with package we're doing, but I know that my caucus is going to ask me about Senate Bill 414. How many bills have we bundled together under this, and how does that comport with the rule regarding bundling? I think we're okay, but if you could help me, I can say the reviser told us it makes it a lot easier in caucus, you see.
Madam Chair and Representative, so the key under the rule is how many you are adding. So if you wanted to count all the things that came into committee, that's a different story, but the rule talks about, so you have the base bill, 414, and you're adding the contents of 3 bills. You're adding 2601, 2741, and a portion of 318. So it's the base plus 3, while that may a whole lot of bills bundled together, it's the base plus 3. So
I appreciate the reviser's explanation. I feel much better in signing this conference report.
Well, gentlemen, it was a pleasure working with each and every one of you, and sounds like we have everyone's going to sign off on the report.
Sounds great. Thank you,
So-
Madam Chair. Thank you, Senate Judiciary, everyone. I know all these will come to the House first, so as soon as we get them signed, we'll run them across House floor and send them to you.
You have
Except for the one you're going to concur on, 318, you just do a
your
concurring.
work to do, and we do as well. And thank you to the Senate Judiciary Committee for its work, to our revisers and staff, and to the House Corrections and Juvenile Justice Committee as well. And with that, then, the committee is adjourned.